Thank you for your testimony. This time, we'll have David Freed, Chief Counsel, California Grand Casino.
Good afternoon, Chairman Gray, Vice Chair Linder, and members of the committee. Thank you for inviting me. Since 1994, I have represented gaming businesses in many states and jurisdictions on licensing, regulatory, and business issues, including card rooms in California. In 2010, I was asked to look at the business models operating for Internet poker and their legal regulation in other jurisdictions. And I was asked today to talk specifically about the issue of tainted assets, which is a different issue than the issue of bad actors, even though they're sometimes confused. Before I talk about that, I just want to say a word about card rooms. As you heard earlier, there are 89 card rooms in California that offer poker and other games. They have 1,800 gaming tables, including 1,100 tables for poker, more than New Jersey and Nevada combined. They provide 22,000 valuable living wage jobs, and they pay hundreds of millions of dollars in taxes that support police, fire, public safety, and social services. While many card rooms hope that Internet poker will increase live poker play at their card rooms, they know that the benefits will go disproportionately to those who participate directly in Internet poker and can tie the two businesses together. So it's essential that all card rooms be able to meaningfully and fully participate in Internet poker if it's legalized, and that the legislation treat all the participants fairly. From the state's perspective, the legislation has to make good sense. There has to be good policy choices. And while we often hear about what a particular group may want in the legislation, what we need is a legislative and regulatory structure that assures the integrity of the operators in the market. And it is in that light, the issue of the integrity of the market, that I want to talk about tainted assets. Now, bad actors deals with people and their companies. The issue of tainted assets deals with what happens to the assets and resources of a company if they sell to someone else, but the assets were developed in conjunction with illegal activity. And I want to explain why the legislation should address tainted assets and address it separately. Just for clarity, there's no dispute that some offshore Internet gambling companies operated without California gambling licenses, without paying tax in California, and yet they took customers in California and they operated illegally. They had no license to offer poker, which is a controlled game in California and which requires a license. They also hid the nature of their financial transactions from banks and payment processors in violation of federal banking, anti-terrorism, and money laundering laws. Commissioner Schutz talked about that earlier. Now, as a result of doing that, they amassed a dominant market position globally, and they had every competitive advantage on those companies that did not take U.S. customers. Now, when those companies were indicted by the federal government, many of the individual defendants pled guilty to their role in the company's acts. They pled guilty to bank fraud and money laundering offenses. The head of PokerStars Payment Processing testified that the senior executives knew that they were evading U.S. banking laws in order to route money offshore. Now, after that, PokerStars paid $750 million to the federal government to settle their charges and the two cases against them. And by virtue of that, it's true that they can say that they were never convicted. But then again, if Richard Nixon were here today, he could say the same thing. The fact is, there was a long history that was documented through those federal convictions and pleas and testimony of what the companies did. Now, when you're running a cash business offshore and without paying tax, where the customers are located, you have a lot of money to spend to bludgeon the competition. And that's what happened with PokerStars, which went from about 10% of the global market in 2005, before other operators withdrew from the U.S., to nearly 65% of the global market today. They advertised more, they hired more celebrities, they had more endorsements, bigger prize pools, and developed more game options. So even in Italy, where they entered a legal market the year after the market opened, by virtue of the resources and customer list and brand they had developed before legalization, today they ended up with 70% of the market. Now that those assets have been sold, from a policy perspective, what should the legislation say about the tainted assets, and why should the answer be in the legislation? Let me give you three things to consider. First, permitting tainted assets to be used provides an incentive for more illegal activity. If people can develop assets illegally and sell them for an enormous gain, if the buyer can be licensed, and use those assets in regulated markets, then you're creating an incentive for people to develop the assets to begin with. In this case, Amaya paid PokerStars 11 times EBITDA for its assets, a very high multiple. At the time, the head of Amaya said it was done with the expectation that with new owners, the assets could be used in U.S. markets. So allowing the assets to be used by a buyer creates an incentive for people to operate gambling illegally and then sell their customer lists and other assets to someone who can get licensed. And in this case, of course, the buyer knew the history of the assets. They knew what they were buying. The second issue is fairness. California gambling operators refrained from offering Internet games because we're lawful and regulated. We couldn't do it. So we didn't develop the same assets. That's true for the tribes. It's true for our card rooms. It's true for the tracks. Allowing the use of those tainted assets against us provides an unfair advantage to whoever wields them. Now, the PokerStars brand name alone, with all the advertising that was done and their growth in the U.S., is formidable. But they also have a customer list of California customers, and they can send emails to those customers at virtually no cost, while everyone else pays tens of millions of dollars to advertise to the general public. Moreover, if the other competitors are offering a sign-up bonus of $100, they can offer a $200 bonus to the 20% of the customers who play often and generate 50% of the business. Now, that list still has significant value. If it didn't, PokerStars would not be fighting so hard to get their tainted assets into the state. What's more, the arguments we sometimes hear about free and fair competition are deceptive. It's like saying, don't worry if the horse was given illegal drugs before the race, so long as there's a new owner, it's okay for the horse to race. The fact is, however, that gambling markets are not free markets. They're highly regulated in order to root out illegal activity, the fruits of illegal activity, and the association with illegal activity. The third reason for you to consider, and this is why the answer should be in the legislation, is that California businesses who want to offer Internet poker will not spend tens of millions of dollars before launch on infrastructure, capital investment, hiring employees, pre-marketing, contracts for services and technology, if market competition is a pretense from the outset. If there's uncertainty in the legislation over the use of tainted assets, many potential license applicants will stay out of the market, and that will cost California competition, hundreds of millions of dollars in economic investment, and tens of millions of dollars in advanced tax payments. Finally, Chairman Kinter made some remarks about the Bureau and Commission. As someone who works with regulators, and I just completed a compliance audit at a card room that took 3 days to complete, the card rooms are heavily regulated. The amount of minutia that they have to comply with in our regulatory rule book is hundreds of pages long. The suggestion that the card rooms are operating illegally is obviously debatable, and there are several Court of Appeal decisions that are published in this state that contradict the remarks you heard before. Because it's beyond the scope of the hearing, though, that's all I will say on that subject. Thank you.
Thank you for your testimony. At this time, Chairperson Valbuena, welcome.
Thank you, Mr. Chairman. Thank you. Well, good afternoon, members of the GO Assembly Committee, and thank you, Chairman Gray, for hosting this very important meeting today. My name is Lynn Valbuena. I am the chairwoman of the Samuel Band of Mission Indians, and we are located approximately 70 miles northeast of Los Angeles. The people of my tribe, the Samuel Band of Mission Indians, have walked a delicate path from our near decimation 150 years ago to become a strong part of our Inland Empire economy. Today, we are proud to be a partner, and we are proud to also be an investor in the health and growth of our surrounding communities with our local city governments. Our embrace of the opportunity for self-sufficiency through tribal gaming has benefited both our tribal people and the surrounding communities as well. We employ upwards of 3,700 people, and 98% are non-Indian people from the local community. It is important to note that after 6 years of debate over authorizing iPoker in California, this year has been the most forward momentum. I think we all kind of realize that now. We believe that AB 431 represents a strong opportunity for mutual benefit of tribal communities and the people of California. A strong coalition of tribes and card rooms have coalesced around common principles, and Chairman Gray's leadership, thank you again, Chairman Gray, has been beneficial in bringing the various parties together. The discussion today is around suitability. Let me be clear. Sam Manuel and our coalition believe the issue of suitability should be left to the California Gambling Control Commission, a nonpartisan entity for whom this is a core mission. Our coalition partnership is committed to moving iPoker forward to protect California consumers. Our partnership with PokerStars reflects this commitment. With its purchase by Amaya, there is a new day, and it is a new day. And Amaya is the most licensed iPoker company in the world, holding unique licenses in a dozen countries. But some opponents' focus on the suitability issue, of course, obscures the larger picture. Of course, suitability standards are very, very important. That is why California has an existing and rigorous process in place to determine those standards and who gets to ultimately hold a gaming license, one which we think has proven to be highly effective. We cannot lose sight of the larger goal to move forward with iPoker regulation. Failing to move forward this year will leave existing players unprotected or possibly allow federal officials to preempt our state's right to offer this form of commercial gaming. We continue to believe that all parties must come together if we are to be successful in authorizing our iPoker. Currently, millions of people are playing poker online with no protections. There are no guarantees for players' money, no support for those who struggle with problem gambling, and no oversight to ensure children cannot access iPoker websites. We have always believed, and we still do, that California should not have bad actors operating online poker in the state. For the past 17 years, regulators at the Department of Justice and the California Gambling Control Commission have done an effective job keeping unsuitable companies and individuals out of gaming. And we believe that states should continue that proven model. Samuel understands and acknowledges the arguments that some have advanced about threats to establish tribal government gaming in the state. Samuel also believes all along that iPoker in California is a commercial gaming matter, not a tribal gaming matter. Economic developments within our reservation communities were made possible because we came together collectively and to pursue opportunities under IGRA and seek voter authorization of tribal gaming. Today, tribes have a chance with iPoker, to grow into another sector of the gaming industry that appears to be getting traction in other states. iPoker is not Indian gaming, it is commercialized gaming, and is not governed by the Indian Gaming Regulatory Act. And we do not believe that our exclusivity for Class 3 or casino-style gaming in California is threatened by authorizing iPoker in California. Voters of the state were clear with their approval of Prop 1A that a limited scope of Class 3 gaming done by Indian tribes on Indian lands under the terms of a negotiated gaming compact was acceptable public policy. So in closing, we know that California's tribal communities share many of these same goals for iPoker, that iPoker should benefit Indian tribes and protect our sovereignty and not diminish our exclusivity for Class 3 gaming in California. The people of my tribe, the Samuel Band of Mission Indians, believe that with the same collective vision and shared commitment to investing in our tribal communities, online poker represents a business opportunity, not a threat to the greater community of California tribes and the state of California. Thank you on behalf of the Samuel Band of Mission Indians for this opportunity to be here and speak at today's hearing. Thank you.
Thank you for your testimony. And now we'll have Eric Hallreiser.
Good afternoon, Mr. Chairman, members of the committee. My name is Eric Hallreiser, and I'm an executive with Amaya and PokerStars. I'm also a former California resident and a current property owner in LA County. I appreciate the opportunity to share with the committee our perspectives regarding the regulation of iPoker in California. In August of last year, Amaya acquired PokerStars. PokerStars is the most licensed online poker operator in the world and the leading global advocate for safe and regulated online poker. We hold online gaming licenses in the UK, France, Spain, Italy, Germany, Denmark, Belgium, Estonia, Bulgaria, Greece, Malta, and the Isle of Man. None of our competitors has as many licenses. PokerStars has dealt more than 135 billion hands of online poker. Now, you don't get to deal 100 billion anything without doing something right. And we do a lot of things right. That's why we're recognized as having established the best practices in online gaming industry in areas including e-commerce, security, game integrity, player fund protection, customer service, responsible gaming, and consumer marketing. There's been a lot of talk about bad actors, and let's not mince words here. There are a few entrenched interests that have worked hard and spent lots of money trying to define PokerStars as bad actors. They are wrong. I want to talk a little bit about UGIA, the Unlawful Internet Gambling Enforcement Act, which took effect in October 2006, and which many in this debate have pointed to as a separation point between good and bad actors. Contrary to what some may think, UGIA did not make online gambling illegal in the U.S. UGIA established enforceable sanctions against processing online payments for already illegal online gambling. Instead, the law deliberately relied on existing federal and state gambling law and existing state tribal gambling compacts. And according to those laws and the opinions of legal scholars, online games of skill, such as poker, were not prohibited. Right after UGIA was passed, out of an abundance of caution, PokerStars got legal advice from U.S. attorneys to ensure that UGIA would not affect our U.S. operations. We were assured that they would not. So we continued operating in good faith, including working at the state and federal level to gain clarity around the legality of online poker in America. We also continued marketing efforts and spent millions in advertising, all in the full light of day. It's important to note that our competitors, who left the market following the passage of UGIA, almost unanimously offered online games of chance and or sports betting in addition to poker. We were poker only. Several of the most prominent of these companies later acknowledged that their previous operations violated federal law. Interestingly, these same companies have returned to the U.S. and have been found to be suitable for gaming licenses. Some will undoubtedly seek to operate in California. I want to talk now about the DOJ's actions on April 15, 2011, otherwise known as Black Friday. On that date, the DOJ filed criminal claims against 11 individuals and civil claims against 3 companies, including PokerStars and Full Tilt, then our biggest competitor. Although we continue to believe that our operations did not violate U.S. laws, PokerStars quickly reached an agreement with the DOJ to immediately stop offering real money online poker to Americans. As part of the agreement, the DOJ allowed us to reopen our site so our U.S. players could withdraw all their funds. To be clear, no criminal charges were ever levied against PokerStars or any of its group companies as a part of the Black Friday events. PokerStars was only the subject of a civil complaint, and that civil complaint was successfully resolved in July 2012. Under the settlement terms, we paid $547 million to the U.S. government. That included the money PokerStars paid to the DOJ to acquire Full Tilt. That's significant because the federal government used those funds to repay Full Tilt's players. And PokerStars also agreed to directly repay $184 million to Full Tilt's players who were outside the U.S. For PokerStars, we benefited by acquiring our previously largest competitor, which continues to be one of the top 10 online poker sites in the world. Finally, one more important point with regard to our settlement with the DOJ, PokerStars admitted to no past wrongdoing. Furthermore, the settlement also included language agreed to by the DOJ stating that PokerStars is eligible to apply for licenses in the United States when they're available. This is significant. After an exhaustive review and lengthy settlement process, the U.S. government maintained our eligibility to participate in the U.S. market. So those are the facts. Now that we've established that PokerStars is not a bad actor, I hope you can see why the use of UGIA is arbitrary and a red herring. It's clear that the entire bad actor push is nothing more than an anti-competitive attempt to keep the world's most successful, most secure, most regulated, and most popular iPoker site out of California. Now, I want to make one note in light of earlier testimony regarding the activities around trading of shares in Amaya. It is certainly true that there's an investigation looking into that trading in advance of the announcement of the transaction. But it's also true that those investigations are very common. There are absolutely no allegations even within that investigation, that Amaya or any of its executives were involved in any insider trading. We conducted our own internal investigation led by independent board members, one of whom was the former head of the Royal Canadian Mounted Police. That investigation found absolutely no violation of any Canadian securities laws by anyone at Amaya. We fully expect that the regulators in Canada will come to the same conclusion. Thank you very much for the time to testify, and I stand ready to answer any of your questions. Thank you.
Okay, thank you for your testimony. At this time, we'll move to Keith Sharp, General Counsel to Hawaiian Gardens Casino.
Good afternoon, Chairman Gray and members of the committee. I serve as General Counsel to Hawaiian Gardens Casino, as you just noted, and several other card rooms throughout California, and I'm also iPoker Counsel to Commerce Casino, Hawaiian Gardens Casino, and the Bicycle Casino, which are the three largest poker rooms in the world. I've been involved in representing and advising the card room industry for more than 32 years concerning matters of regulation, compliance, operations, and management. Let me begin by thanking the Chairman for his leadership on this important issue and providing me the opportunity to testify today. My clients firmly believe that Internet poker will provide necessary consumer protections and revenue to the state and will benefit our brick-and-mortar operations, thereby creating jobs and enhancing tax revenue to our local communities, many of which are underserved. That is why we have been proponents of this issue for more than 7 years. We recognize that a primary factor in our success has been and continues to be that we welcome and embrace the importance of a fair but strict regulatory process which ensures the integrity of all industry participants and their operations. In the card room industry, that framework is set out in the Gambling Control Act and its implementing regulations. Having been involved in the drafting of the Gambling Control Act, I can assure you that considerable deliberate thought was given by this legislature to providing our state regulators with the guidance, tools, and resources needed to appropriately regulate and police the industry. Dealing with the Act on an almost daily basis over the past 17 years, I can confirm to you that it works very well. It is not coincidental that every substantive Internet poker bill introduced over the past 7 years has borrowed heavily from the Act in terms of suitability criteria. And the primary reason that the Act has worked so well is that we have tremendously competent regulators, including those whom you met on the previous panel, who are expert in investigating and backgrounding applicants, in assessing suitability, and ensuring that criminal and other undesirable elements are not permitted to participate in the industry in any manner. I have interfaced with the Bureau of Gambling Control and appeared before the Gambling Control Commission as much and perhaps more than any other individual. I have seen the regulators in action firsthand on numerous issues. I have won some and I've lost some, but I've always known that whatever the issue is at hand, it was thoroughly vetted by the regulators in each and every respect. From an applicant's perspective, I can tell you, as Mr. Freed pointed out earlier, they review every aspect of your life and background, every bank deposit and withdrawal, every ATM withdrawal. They interview your friends. They interview your neighbors. They interview your ex-spouses. They go to foreign countries where you may be doing business to see what you're up to. And that's just on the DOJ level. Then you get to the commission where, as a result of the public meeting rule, intimate details of your life are often discussed and questioned in public, and thoroughly so. I urge you to visit the Commission website to see for yourselves the number of administrative and disciplinary actions initiated by the DOJ and taken up by the Commission, as well as the continuous rulemaking engaged in by the Commission with the assistance of the DOJ as the Commission seeks to fulfill its mission. We have said from the very beginning of this debate that these same high standards of suitability and regulatory expertise should absolutely be brought to bear in the context of California's online poker industry. The legislature should continue to provide the regulators with the authority and all of the tools and resources which they have so ably applied for the more than 17 years and allow them to do their jobs. At last month's joint informational hearing and again today, the regulators confirmed that given adequate resources, they are confident that they can do the job and that the Gambling Control Act is an adequate tool in determining suitability standards which can be applied to Internet poker. You have heard today, and you'll likely continue to hear from certain special interests, that the Gambling Control Act is not good enough for Internet poker, that it must be changed, must be deviated from to add a single-purpose ban on so-called bad actors which would be narrowly defined to exclude but a single entity, Amaya PokerStars, the world leader in online poker, as you heard. Such a bad actor clause could not be a more blatant, arbitrary, anti-competitive, or unfair provision. You don't hear anybody's name other than Amaya PokerStars now mentioned in that context. And it's no coincidence that they're the largest and they're the company that no one wants to compete with. That kind of provision places the legislature in the difficult position of artificially shaping the competitive market, of legislatively picking winners and losers, and it takes from the regulators the very essence of the task that they are charged to perform. Let's be clear, the use of anti-competitive language and random cutoff dates in legislation have nothing to do with protecting consumers or legitimate state interests. Those who advocate for such a position would have the legislature act as judge, jury, and executioner. However, as Harvard law professor and foremost constitutional legal scholar Lawrence Tribe opined last year when he visited this very building, conviction by legislation is simply unconstitutional. Those who advocate for it are simply inserting into legislation what they know to be a poison pill. And even if the legislature was so inclined to predetermine individual suitability, where would the proverbial line be drawn? Should those who have admitted certain transgressions or who had offered full casino gambling over the internet or others also be summarily excluded? I'm not advocating for such language, but simply pointing out that this is precisely the type of morass that is created when winners and losers are legislatively determined. The Gambling Control Act has a bright, legislatively mandated line. If you've been convicted of a felony or a crime of moral turpitude, you cannot hold a California cardroom license. These are objective, historically recognized disqualifying factors for many licenses and privileges, which recognize that a court of law has made a determination based on a process which allows for a full and fair vetting and protects fundamental due process rights. Beyond this bright line, however, the application of suitability criteria and determination of suitability is left to the expertise of the regulators as applied to each unique applicant and each unique situation. And while that regulatory discretion is quite broad, if an applicant disagrees with the suitability determination, regulatory due process then allows that applicant a pathway to appeal. Chairman Gray and members, I respectfully urge you to recognize that we have the necessary legislative framework as regards suitability standards already in place via the Gambling Control Act, which in its 17 years of existence has not, to my knowledge, ever been challenged as being inadequate in keeping unsuitable persons out of the gambling industry. I urge you to preserve the state's existing regulatory system just as New Jersey and Delaware have done in their online poker laws, in which expert state gambling regulators equally apply stringent suitability standards to online poker operators. And please recognize that, as the case with virtually every industry, the best thing for consumers in the state is a robust, competitive marketplace which provides consumer choice from among trusted operators who have all been subjected to and have met the strict suitability standards of the Gambling Control Act. My clients and the coalition of which we are a part wholeheartedly support the application of the highest suitability standards to online poker licensees and subcontractors, just as they are applied to the cardroom industry to ensure that true bad actors, whomever they may be, do not participate in iPoker. Those standards are in the Gambling Control Act, and its implementing regulations have worked well for 17 years. We urge you to let the regulators continue to do the job and give them all the resources and tools that they need to do their job. And on one final item, to a point that the chairman, I believe, made early on in terms of some of the things going on in the urgency of this matter with some of the things going on elsewhere, including in Washington, D.C. I understand, as just before this panel started, that I heard that today Senator Lindsey Graham introduced a bill to ban Internet gaming on a federal level. Thank you again for the opportunity to present our views.